What's the difference between a revocable and an irrevocable trust? Hi, I'm Dan Covington. I'm an estate planning attorney. I help people put together the estate plan and leave the legacy they intend. Differences between revocable and irrevocable trust. It's not simply a matter of one can be revoked or amended and the other cannot, as a general matter. Most people that you know who have a traditional trust, they have a revocable trust. Irrevocable trusts are typically for some kind of special purpose. There are lots of exceptions to this kind of general introduction, but let me highlight the main points. With a revocable trust, of course, as I said, you can revoke it, you can amend it. Usually the primary purpose of a revocable trust is to pass assets along to your family. It has a few key features you've probably heard me talk about before. It passes those assets without probate. It can pass those assets kind of in a lot of ways and under conditions and contingencies for distributions if you want it to do that way. For example, you can pass things after the death of you or after the death of you and your spouse. It can go to my children, but only after they reach age 25, or it can go to my nephew, but only for need-based support for his post-secondary education up to $80,000, something to that effect. You can put all kinds of conditions. These are provisions you can put in your trust, and your trustee is bound to administer the funds based on those provisions. Of course, with a revocable trust, the assets remain in control. This is a key difference. The assets remain in control of the grantors. The grantors are those who started and funded the trust. So at any time, they could pull those assets out of the trust, or they could use it for something else, or they could nix the idea of the trust altogether. I really don't find that happening, but in theory that could. But they keep control over those assets. They can take them in and out of the trust once it's in the trust, unlike an irrevocable trust. With a revocable trust, once the assets are in, you can still make changes. But a revocable trust does become irrevocable at the death of, depending on how it's written, one or more of the grantors. The trust still operates and it still works, but it's not so susceptible to change or revocation at that point. Now, with an irrevocable trust, of course you can't, for the most part, there's, like I said, exceptions to everything I'm saying today. For the most part, you can't revoke an irrevocable trust, and you can't amend it. You can't change it down the line, and you'll kind of see why when I tell you why people do irrevocable trusts. The primary purpose with an irrevocable trust is to remove assets from control of the grantor, and that seems like an odd thing, perhaps, but there's a few reasons why folks once in a while decide to do this. And I can tell you, I've only written a handful of these in 20 plus years. They're not bad; they're just unusual. They're a different aim that the estate planner has. Primary purpose of an irrevocable trust is usually to remove assets from the grantor's control. One of those reasons might be to, back in the day, to remove it from their taxable estate if they believed they would die. For instance, when I started doing this, it was under $1 million. If they would die with under $1 million, they might have estate tax consequences. Well, now that's more like $11.5 million. So there's one reason why that's not happening so much anymore. Another reason they might want to remove assets from their control is so that authorities don't count these assets if the grantor or grantors need to go into nursing care, i.e. they're looking for Medicaid qualification. There are very particular rules federally and by state for this, so this is a special kind of trust. Another reason, maybe you've thought of this when I first said remove assets from their control, but they do so in hopes that their assets are beyond reach of potential creditors. I guess I'll say they're in some kind of high risk occupation or something where there's just a lot of litigation, people might do this so that the main theory behind this is if a creditor might be coming after you and you set your assets aside in this trust that you still have full control over, revocable trust, right? Well, the theory is the creditor may have access to those assets because you do. Why shouldn't they? With an irrevocable trust, the theory is it's out of your control, so maybe the creditor doesn't have such a shot at garnishment or attachment of those assets. So again, I hope I haven't muddied the waters too much. Suffice it to say, most folks need a revocable trust. An irrevocable trust is a different animal. It is about purpose when we're deciding whether to do one or the other, and this topic is maybe more hype than reality, because it's not very often that people are really looking and interested in an irrevocable trust. Most folks with a traditional estate planning trust are looking for a revocable. So when you ask me which do I need, again, the answer is going to depend on the primary aim of your trust. I'm Dan Covington. You can always find me at Estate Plan Kansas. I hope this helps you out.